Welcome. It's nice to see you all. My name is Ari Kelman. I'm on the faculty of the Graduate School of Education. I am also an affiliate of the Toby Center for Jewish Studies. So this is the second in our How to Think About Antisemitism series, and it's my pleasure to introduce Professor David Schraub. Professor Schraub is an associate professor of law at Lewis and Clark Law School, where he joined the faculty in 2021. He holds a PhD in political science, and he is fast becoming one of the keenest observers and most insightful analysts of American Jewish life. I've read Professor Schraub's work for a number of years in both journalistic and scholarly settings. He has also, I should add, maintained a pretty active blog since 2004. It's so active that I can't keep up with it in terms of reading, and I can't even imagine writing at that pace. And it's wide-ranging and clever and smart and great. And when I began putting this series together, and I began to think about it last spring, as we were winding down last year, he was the first person that I reached out to and topped the list of people that I wanted to invite. He occupies a unique place in scholarship on American Jews and increasingly on anti-Semitism. As a legal scholar, he employs an uncommon set of methodological and theoretical tools to the question of American Jewry that allow him to present analyses and insights that have long evaded our colleagues who are more typically situated in the humanities or, like me, in the social sciences. Beginning with questions of law, he's written about concepts like intersectionality and trust, about charges of bad faith, and most recently, the questions raised by a spate of legal rulings on religious freedom and how they are shaping how legal questions shape Jews and Jewish concerns in American society. So to sort of encapsulate some of that, rather than focusing on how Jews have leveraged the law, and there's been a lot of scholarship on that, Professor Schraub flips the framework to ask how the law has constructed Jewishness, and then proceeds to ask what the implications of that are for Jews and everyone else. Lately, he's turned his attention to anti-Semitism, although it's been there in his work for quite a while. Instead of arguing for a singular definition of anti-Semitism, and there's no shortage of writing that does that, or why this organization or that legal framework does or does not work, Professor Schraub has delicately excavated how certain legal constructs can emphasize and even perpetuate anti-Semitic beliefs. His analyses are parsimonious, carefully argued, sharply insightful, and hard to pin down politically. All of these are qualities of exemplary scholarship writ large. They're also exactly what we need to inform our conversations and our learning about Jews and anti-Semitism, which is why I was so excited to bring him, and I'm so glad he's here. So with all of that, thank you, Professor Schraub, for making the trip from up north. Welcome.
Thank you for that incredibly generous introduction. I'm up for tenure next year, and I think I know who one of my external reviewer proposals is going to be. I'm particularly grateful for this invitation for all of the normal reasons, but also because I think it is very important to be having these conversations in a situation where, leaving aside the alarming growth in anti-Semitism that we've been seeing over the past several years, a parallel problem in academic spaces where in too many contexts and in too many places, discussions about anti-Semitism and really all of the isms, racism and sexism, colonialism, are too often not treated as full and legitimate subjects of scholarly inquiry. And we see this, for example, most prominently, I think, in Florida, where certain types, the wrong types, we can say, of investigations into racism are severely disadvantaged by the state, if not outright prohibited, right? And the overarching framework, and we unfortunately see this with anti-Semitism too, is treating anti-Semitism, treating these isms not as subjects of legitimate scholarly inquiry and potentially dispute, but rather as forms of censorship, of shutting down speech, of not of making claims, but of stopping claims from being made. And I think that is severely problematic. I think we need to talk about anti-Semitism as something that we discuss, and as something that we sometimes debate, and as something that we sometimes disagree about. And all of that is okay, and all of that is normal in academic spaces. And so just, treating anti-Semitism not as something that obstructs a conversation, but as something that can produce a conversation, is too often a rarity in academic spaces. And so I'm especially grateful to have this opportunity. What I want to focus my talk today is on some evolutions in free exercise jurisprudence and how they relate to Jews generally, but liberal Jews specifically. And in doing so, I'm going to suggest that a particular modality of anti-Semitism has become or is becoming the preferred way for a particular type of politics around religious freedom to deal with and metabolize what would otherwise be a very serious challenge that liberal Jews present to a new free exercise jurisprudence. Over the last several years, we have seen a sea change in how religious liberty is treated by the federal judiciary. And this has occurred through a series of high-profile cases, virtually all of which have involved conservative Christian litigants challenging the application of liberal policy priorities. So you think things like COVID restrictions, vaccine policies, pronoun policies for trans students, sexual orientation discrimination. The common theme, again, is conservative Christianity challenging liberal policy priorities. And so religious liberty gets coded as conservative, challenging liberalism. And this has generated a sharp partisan split in what had, until again, relatively recently, been a pretty sleepy backwater of constitutional jurisprudence, with conservative judges overwhelmingly voting to grant exemptions to the challenging plaintiffs and liberal judges overwhelmingly voting to deny. So again, that whole framework has been developing with a particular modality of religion in mind, of conservative Christianity. And I want to think a little bit, though, about how this free exercise jurisprudence will engage with the case of liberal Jews. By that term, I mean to refer to two separate but overlapping categories, which is to say non-Orthodox Jews, Reform, Reconstruction, and conservative, and then also politically liberal Jews. These aren't the same, but they're increasingly overlapping, right? Most American Jews are not Orthodox, and most are politically left of center, upwards around 70%, according to most polling. But the minority of Orthodox Jews are increasingly conservative. So we're starting to see some consilience between these two different categories. And the thing about liberal Jews is they present a challenge to free exercise jurisprudence because they are liberal. And so they flip the script of this new free exercise jurisprudence, as well as many commonly held stereotypical assumptions of what constitutes religiosity. And so there are several arenas where liberal Jews might be posing religious freedom challenges to conservative policy priorities. Almost certainly, abortion is the most prominent of these. Judaism in general, and certainly the more liberal denominations in particular, take a far more permissive view of abortion than do many Christian denominations. And there are several instances where Jewish law views abortion as religiously obligatory. And my argument is going to be that liberal Jewish religious liberty claims do have purchase under the new free exercise regime. If you take the doctrine as the courts have been articulating it, a lot of these challenges that we're seeing, not all of them, but a lot of them, should have some legs to them. But I'm very skeptical that the judges who have promulgated this doctrine are going to want to give religious exemptions to the newfound abortion restrictions. And so the question is, how do we manage that tension? Now, all of this illuminates a kind of deeper problem with the new free exercise, which is that if it is truly open to everybody, if it's not just something reserved to conservative Christian claimants, but every type of religious actor can access it, it runs the risk of anarchy, right? And at the very least, it poses problems and threats for important conservative policy priorities, like abortion restrictions. That has been masked so far by the fact that most of the plaintiffs' identities have been conservative Christians, or those allied with them, as well as an unstated presumption that religiosity and conservatism are inherently aligned. But liberal Jews challenge that presumption and so bring the contradictions of the new free exercise doctrine to the forefront. And in order to resolve those contradictions, judges will either have to jettison this new doctrine, which I think is unlikely, or accept near anarchy as every policy becomes subject to these religious exemptions, which I also think is unlikely, or, door number 3, find a way to cabin the doctrine in order to lock liberal Jews out while still preserving expansive protections for conservative Christians. And my hypothesis is that the judges are in luck in their desire to go through door number 3, because fortunately for them, unfortunately for me, long-standing patterns of anti-Semitic discourse offer a huge welter of resources by which Christian society can decide which Jews count as Jews and which do not. Those resources, in turn, will delegitimate liberal Jews' claims to even be Jewish or be authentically Jewish, removing them from the ambit of a valid free exercise claim, and thus metabolizing the dissonance liberal Jews pose to this new constitutional order. So I'm going to walk through what this kind of new doctrine is and how it works and how Jews would be able on face to level a claim against it, then talk about the sort of what I'm going to term a new supersessionism, that enables liberal Jews to be locked out of religiosity and making authentic claims. Talk a little bit about how then that new supersessionism can work inside of the current doctrine to lock Jews out. And then finally, the last thing I want to talk about is how does this affect what we call Jew-on-Jew predations, right? How do Jews sometimes themselves contribute to what I will argue to be this sort of anti-Semitic discourse? So we can start with the new free exercise. And we'll start with the new one by talking about the old one, which was based around a very important 1990 decision called Employment Division of Oregon v. Smith. And that held that if a law was generally applicable, right, it's not religious targeting, it doesn't single religion out for disfavor, that it does not violate the free exercise clause, even if it incidentally has an impact on a given person's religious practice. So that case involved a federal law which banned the use of peyote, and somebody, a Native American religious adherent who used peyote as part of their sacrament sues and says, I need to use this as part of my religion. And the court says, this law doesn't single out your religion. This law wasn't targeted at your religion. It's just sort of bad luck that it captures your religion. And the fact that a law kind of just so happens to have the effect of burdening religious practice does not constitute a First Amendment violation. That was the old regime. That regime was very controversial for a long time, almost from its inception. And initially it was a bipartisan controversy. And so the new free exercise doctrine that's emerged is sometimes characterized as adopting a most favored nation status for religion. And under that rule, where a law has exemptions to its general rule, so where there are some groups or some practices that get exempted, then religious objectors must gain at least as favorable treatment as does the comparable group with the most generous exemption. So in one of the COVID era cases, Tandon v. Newsom, there was a law that had COVID restrictions and limited large gatherings to restrict COVID spread, but it allowed some large congregations of people, allowed them in, like, for example, grocery stores, were allowed to have a larger number of people than many other places. And so the court held that because you gave that sort of exemption to grocery stores, you had to give a similar exemption to religious gatherings. They also must be allowed to have more people than normally would be allowed in under the standard COVID rules. Now, the issue with this approach is that virtually no law is generally applicable, if by that we mean it has no exemptions whatsoever, right? All laws, right, have some exemptions, and so all laws, it would seem, need to provide these sort of religious exemptions to the maximum possible degree, right? And so while the court says it's going to apply strict scrutiny in these contexts and say that, you can't deny the religious exemption unless you can show that the law is narrowly tailored to a compelling state interest, they all end up failing strict scrutiny because courts generally take the existence of exemptions as proof that the interest being pursued isn't all that compelling, right? The way the courts have framed the question is to ask whether a religious exemption would impede the interest in any materially different fashion than the permitted non-religious exemptions, and this often leads to my mind, absurd results. For example, the compelling interest in vaccination is to limit the spread of disease. But medical exemptees are just as spread-prone as religious exemptees, and so some courts have said that the existence of a medical exemption to a vaccination requirement, people who get an exemption because a vaccine would be dangerous to their health, necessarily means that a religious exemption must be provided as well. And lower courts have taken this approach and they've ran with it hard. So I'll give a couple of examples from real cases. In the Northern District of Texas, there was a challenge to Title VII, which is our employment discrimination law. Title VII exempts very small businesses from its coverage, right? And so the court says, well, if you exempt small businesses, you have to exempt religious employers as well. They have to be allowed to discriminate on the basis of sex or sexual orientation if they so wish. Same thing about the Navy, exempting personnel from vaccine requirements for medical reasons. They're also getting it for religious objectors. The District of Columbia District Court enjoined rules allowing minors to choose to be vaccinated without parental consent because the district has slightly different reporting procedures where the parents withheld consent for religious versus medical reasons. They said that's singling out religion for disfavor. They can't have that. In the District of Kansas, they enjoined a rule forbidding teachers from non-consensually disclosing a student's pronouns to their parents because the student did not punish inadvertent disclosures. They said that was an exemption, therefore you need to have a religious exemption as well. So this is an extremely expansive framework for claiming exemptions. What happens when liberal Jews try to press a claim under it? Well, abortion is where we're going to see this, and we're already seeing this most prominently. Jews are overwhelmingly pro-choice. 82% of Jews oppose Dobbs overturning Roe v. Wade. There is more consensus amongst American Jews on abortion than pretty much any other issue area. More than guns, more than Israel, more than the Iran deal, more than Democrat versus Republican. Really, this is the single area where there is the most uniformity amongst the American Jewish population, right? All Jewish sects agree that abortion is not just permitted, but is in fact mandatory in circumstances where the mother's life is threatened. Beyond that, there is significant disagreements between different denominations. Liberal Jews, perhaps unsurprisingly, take a more liberal tack, generally insisting on deference to the pregnant person's own judgment on whether the pregnancy ought to be continued or terminated. And one commentator summarized this approach as her pain prevails and her judgment respected. Crucial under this approach is the view that abortion decisions are made in a case-by-case setting by the pregnant person in consultation with those closest to her, the family, medical professionals, and so on. Now, I'm not here to say that's the right Jewish position, only that there are many Jews for whom that is their religious position, and they may challenge abortion limits insofar as they interfere with those scruples. So what happens when they say, I have a religious liberty interest in procuring an abortion that is now barred by law? Well, this is not an issue that defenders of these restrictions have not thought about, and they have several objections for why they think that religious liberty claim shouldn't go through. The most prominent one, and defended by, among others, Michael McConnell, who's right here at Stanford Law, says that the Jewish approach, as this is being articulated, is a matter of choice, not obligation. Jews are saying, I have the right, I want to be able to choose an abortion. They're not saying, I am obligated to have an abortion, right? And these religious liberty claims should only apply in situations where you feel obliged to take a certain act, not just that you have the right to make a decision in either direction. If either direction is okay, then there's no religious liberty harm that law forces you towards one particular choice that you are allowed to make. But there are a bunch of problems with McConnell's objection here. First of all, sometimes it is an obligation, as we've talked about in life-threatening cases. But more fundamentally, choice and obligation are not always opposites. And it's entirely conceivable that one could perceive an obligation to follow the dictates of one's conscience after full consideration. Viewing religious obligations as inherently illiberal, right, as constraints on judgment, I think, in my view, is not really compatible with how many Jews view what our religion demands, and seems very influenced by a particular conservative Christian articulation of religion. Many Jews take religious obligation not as sort of unquestioning adherence to divine dictates, but as an ongoing dialogic confrontation in which individual reason and judgment are absolutely valid elements and the result of which can still generate valid religious obligations. And this is where I point out that the word Israel literally means wrestles with God, right? It is about having that sort of conscientious deliberation. So what we're having, the mistake that's being made here is a confusion of choice with agnosticism. Judaism may well respect people's choice with respect to abortion. That does not mean it is religiously agnostic to the question of abortion, right? There are things that we are religiously agnostic to, and we say we just don't care what you do about them. It's kind of up to you, right? But the her pain prevails and her judgment respected approach suggests that what's obligatory is respect for the process of free choice and autonomous judgment. That is what is being breached by these laws. And finally, even if you don't buy any of that, there's still the question of Jewish doctors, right? Doctors might perceive a much more traditional form of obligation if they encounter a woman who sincerely desires an abortion, and they think they are obliged religiously to say her pain prevails and her judgment respected, but are forbidden from acting out on that obligation by state law. Once the woman renders her judgment on the need for an abortion, the doctor is obligated to carry that judgment through, and this is particularly important because many state abortion laws only punish the doctor. Another objection that's raised to the religious liberty claims is they say, well, there might be a valid claim here, but it's trumped by the compelling interest in fetal life. But here we see, once again, the difficulties posed by this extremely broad free exercise jurisprudence that the Supreme Court has wrought, because that compelling interest is undermined by the existence of exceptions. Rape or incest or health exceptions to abortion terminate fetal life to the same degree as religious objections. So under the logic of a case like Tandon, most favored nation rules require extending the religious obligation to the most generous exception given, and those permit abortion. And so finally, when I made this argument, some of my colleagues who defend these sorts of restrictions say, well, if that's the case, then this is anarchy, right? No law could survive a challenge when things are as broad as this, at least when the challenge is sincere. And my response to that is, you're right? It is anarchy, and that is the problem with the new free exercise. There is no chance that the court could really follow this doctrine to the logic of its limits, right? And so how to resolve it without dropping the doctrine whatsoever, the answer has to be to cabin the new free exercise so it only protects those who are meant to be protected while still binding those who are meant to be bound. How is the judiciary going to justify this? Well, here I want to talk about what I'm terming the new supersessionism, and it's an ascendant version or an ascendant type of anti-Semitism, which I think we're seeing increasingly commonly in public discourse, and has, I think, a lot of attraction for locking Jews out of claims they would otherwise be entitled to. The general version of this is that Christianity and Christian hegemony constructs itself as emblematic of what religion means, generally against secularism. Again, Jewishness threatens that construct insofar as it religiously defends values often coded as secular, opposing prayer in school or supporting abortion rights, right? And so we see instead an attempt to kind of conflate everything under an umbrella of Christianity, and Jewishness only counts when it fits within that framework, right? So it's not the case that Jews can never be covered by the new free exercise, but they could only be covered insofar as Jewishness happens to align with Christian priorities. Judeo-Christian is 100% Christian, right? And I always say, if you have reservations on that, think back to the last time a politician said they were defending Judeo-Christian values on abortion or the death penalty. And did it even occur to you that when they said that they didn't mean a conservative Christian view, right? Or indeed whether they had even referenced a Jewish text at any point whatsoever. We all know what the term means, and the term means Christian. But beyond the sort of general assertion of Christian hegemony, there's obviously a more particular history of supersessionism with respect to Judaism and Christianity. Because Christianity grew out of Judaism and has appropriated key Jewish texts, it has an inherent interest as a religion on what the authoritative meaning of Judaism is. And that means that Christianity is theologically vulnerable to Jewish articulations of what Jewishness is that run counter to the Christian view. So there's an incentive for Christians to neutralize that threat by deciding for themselves what Judaism really is, regardless of how Jews might opine on the question. So traditional supersessionism is the theological view that Christ's arrival superseded God's covenant with the Jewish people. I'm using it a bit more broadly here to speak of the claimed entitlement of Christianity to authoritatively declare, even over Jewish objections, what counts as truly Jewish. Sometimes people say for Christians, Paul just got Judaism right? And today's Jews are wrong about what Judaism is. The ability to declare some Jews, or perhaps even most Jews, as bad or inauthentic Jews is deeply written into Christian patrimony, and still exists in modernity through constructs like Judeo-Christian. To the extent Jews kind of depart from these Judeo-Christian beliefs, then they don't count as Jews anymore, that's taken to delegitimize them as Jews because they're not Christians. And if they're not really Jews, then hating them or denigrating them or discriminating against them isn't anti-Semitism. Because if anything, they're philo-Semitic towards the Jews that count, the rump remainder. So I sometimes say they love Jews, in quotes, this sort of image of Jews they've constructed for themselves. They hate Jews, no quotes, the actual flesh and blood Jews who don't align with this Christian construction. And so we see, unfortunately, the spectacle of Christians declaring that Jews are not really Jews because they take positions that most Jews take, support for abortion, support for gay rights, or just being a Democrat, There's a bunch of examples here. One of my favorite was when Rudy Giuliani said that he's a better Jew than George Soros is because, unlike George Soros, Giuliani goes to church regularly. That's not really the marker of what being a good Jew is all about, J.D. Hayworth, who is a former Republican congressman from Arizona, had campaign surrogates get booed out of a synagogue when they told them that he was a better Jew, he is not Jewish, better Jew than all the people in the synagogue was because he was pro-life and they weren't. And more recently, in the 2022 Senate race in Pennsylvania, an advisor for Doug Mastriano, who is the Republican candidate, tried to argue that Josh Shapiro's claimed Jewishness is inauthentic because of his liberalism, and she said he is, at best, a secular Jew. Successfully degrading the status of liberal Jews as not real Jews metabolizes the dissonance that liberal Jews cause to the narrative of religious liberty, which generally presents and completes it with conservative Christian frameworks. The refusal to accommodate liberal Jews' religious objections no longer codes as a failure of religious liberty because they aren't being recognized as Jews or as religious in the first place, And so when we see these efforts, for example, to limit the notion of religious burdens to those that fit within a more conservative Christian frame, that is a way, again, of departing or removing very normal Jewish religious liberty articulations from what counts as religious. So T.S. Eliot, many years ago, denigrated what he called free-thinking Jews as not Jews at all, but a mild and colorless form of Unitarianism, Jews who adopt what is amongst Jews a very popular liberal dialogic approach to religiosity will be deemed to just not be religious at all. A very prominent conservative religious liberty group, the Becket Fund, filed a brief against Jews who sought state-level religious freedom relief against Indiana's anti-abortion bills. Virtually all of that brief, in terms of its substantive argument, was spent arguing that the plaintiffs should not be deemed even sincere in their religious beliefs. Even though, again, their articulations of what Judaism requires with respect to abortion is very commonplace in the Jewish community. Josh Blackman, who is a prominent conservative law professor at the University South Texas Law School, at one point suggested that liberal Jews should just categorically be denied the ability to make religious liberty claims. He's retreated off that view, in part, I have to say, from reading one of my articles, but not as far as he claims he has, and the language that he's used is really replete with degrading rhetoric, because even though he seems to recognize that the beliefs in question are sincerely held, they're not just made up for the purpose of litigation, he characterizes liberal Jews as gerrymandering their objections in an opportunistic fashion to appeal to a conservative court, and suggests that liberal Jewish claims just cannot be deemed to be sincere because they don't believe in the binding nature of halakha, and so their claims just must be political opportunism. As a matter of law, he's just wrong, the Religious Freedom Restoration Act and other related statutes explicitly reject the notion that one must prove a religious belief to be obligatory in the way that he's talking about. But there's, again, this deeper attitudinal disdain towards liberal Jews, conflating not having orthodox beliefs regarding the bindingness of halakha with a complete disregard for religious importance of particular values. The Jew who does not believe the laws of kosher are binding also is one who eats pork every day, right? And so cannot possibly be sincere in claiming a religious burden when he maybe is forced to eat non-kosher food, right? The former simply doesn't entail the latter, right? Many liberal Jews, I'll count myself among them, do not view the traditional laws of kosher as obligatory in the very strong sense that Blackman is talking about, but I nonetheless keep kosher as a part of my religious observance. And the ease of which Jews like me have our existence occluded, and again, we're likely representing most American Jews, is a very worrisome indicator. So all of this, I think, presents a significant problem. But it's a way, again, the prominence and the growing prominence of this method of dismissing liberal Jews as not real Jews offers a way to restrict this expansive religious liberty doctrine to those who truly deserve it, right? And those who truly deserve it being envisioned to be these authentically conservative Christian claimants. Jews might be able to partake, but only to the extent that they align with that Christian claimant. So it would be a minority of Jews who adopt that sort of view. And so I want to wrap up by talking a little bit about that minority and talking about religious pluralism here. Because, yeah, most Jews are liberal Jews, not all are. And some Jews agree with the Christian majority on the issues we're talking about. They quite sincerely oppose abortion rights, for example. And while I've been focusing on the way that Christian speakers, right, construct Jews or certain Jews as not real Jews, there is an internal version of this dialogue where some Jews whose views comport with the Christian majority exploit the situation to their own benefit. Right? Ben Shapiro does this quite regularly. He speaks disdainfully of liberals with Jewish last names, right? The implication being that because they are liberal, they're not really Jewish, only their names are, but they shouldn't otherwise count. So when I talked earlier about how people love Jews in quotes, which is to say the mental image they've constructed of what a real Jew is, but they hate Jews, no quotes, insofar as they don't match up with that image, part of this is exploiting and trying to, win the terrain of who counts as the Jew, the in quotes Jew, in the public imagination, and trying to align oneself with that view. And I want to stress that what counts as the Jew in quotes, right, will vary from person to person. When we're talking about a conservative Christian, maybe they're envisioning this sort of Judeo-Christian warrior who's standing as a bulwark against the encroaching tides of secular modernity. But others will fill in that blank differently. And they might see the true Jews as noble victims, right, who are eager to sacrifice themselves on the altar of humanitarian universalism. And might react quite the same way when non-quote Jews don't want to play the role that is assigned to them. The point is, though, that even amongst those who want to be allies of Jews in quotes, often what they really want is to be, for the Jews they've already allied with, to be the Jews of the collective public imagination, to be the Jews who count as Jews. And this in turn generates incentives for those Jews who do match on to a particular version or particular vision of Jews in quotes to facilitate that replacement, to encourage and promote the idea that they are the real Jews. And so non-liberal Jews, in fact, can reap many tangible benefits to the extent that they can replace the Jewish majority as the publicly recognized emblem of Jewish sentiment. And they have an incentive to encourage, unfortunately, the anti-Semitic denigration of the Jewish majority, and we're seeing some, in fact, do indulge. The broader point that's being raised here, and the broader controversy, is that in a world of identity capitalism, who is deemed to speak for a group or be a representative of a group? And that's what we're talking about: Jews, blacks, Arabs, Catholics, gays, whomever. It matters. right? And so we see these sustained efforts to fight over who claims to count as a collective representative and to destabilize attempts, even by groups that have a credible claim to majority sentiment, from claiming that mantle place. In a different register, the challenge by anti-Zionist Jews to the claims that groups like Hillel or the Jewish Federation can speak on behalf of the Jewish community is a similar effort by an internal minority harboring a dissident opinion to challenge an assertion or a status quo over who gets to be the public representative or the face of Jews. And so one thing we're seeing here is that the whole notion that some particular faction, even a majority faction, gets to serve as a representative for a group is both inherent to any sort of group-based political organizing. It's not something that can be avoided, right? But it also is inherently in tension with intra-group pluralism. For any value, principle, or interest we might associate with a given identity group, there will always be some dissent and some diversity of opinion. So in other scholarship, I wrote out a hypothesis that not all X's believe Y will be true of any issue X of non-trivial, any issue X, or any group X of non-trivial size for any issue Y of non-trivial contestability, where X is not literally defined by belief in Y. And that maxim has proven surprisingly resilient against counterexamples. Right? I can point you to black opponents of the civil rights movement in the 1950s and 60s. I can point you to Jews who supported Hitler in the 1930s. Right? There's always going to be someone. Right? So how to mediate the need for some degree of representation when speaking of groups versus recognizing the very important rights of internal dissenting minorities, of which both Jewish conservatives and Jewish anti-Zionists are, to articulate that dissent, is really, really challenging. And what I argued in my other paper is that what the dissident minority can't do is they can't tokenize themselves. And by that I mean they cannot hold themselves out as a substitute for whatever engagement obligations there are towards the group as a whole, right? And so in this respect, what the right-wing Jews are doing wrong in how they participate in this discourse isn't that they harbor a dissenting opinion on abortion or anything else, right? And it's not that they express that opinion as Jews. They're absolutely entitled to do that as well. What's wrong is that they sometimes try to legitimize as sufficient interacting with them, as like you have satisfied your obligation to talk to Jews just by talking to them. And I would make that same critique towards some anti-Zionist Jews as well, right? They absolutely are entitled to the dissenting view, right? They are absolutely entitled to present their view as a Jewish view, right? But what can be problematic is when they hold themselves out to non-Jews as a sufficient mechanism for satisfying whatever obligations might exist to stand with or engage with or stand in solidarity with Jews as a whole. So ultimately, respect for Jewish political equality when it comes to religious liberty or anything else means at least some, not undeferential, but some measure of respect for Jews as we constitute ourselves. And in contemporary America, that means one has to respect Jewish liberalism, not because that's the only true way to be Jewish or authentically Jewish, but because it currently represents the majority faction of Judaism. And that respect is not in any way incompatible with recognizing Jewish religious pluralism, but acknowledgement of Jewish pluralism, in turn, is not a license for elevating a preferred minority of Jews to replace the Jewish majority as the only ones that count. And so to the extent a Jewish minority tries to make such a move, that really is problematic. And it's an endeavor that can be called out without it being seen as a disrespect for Jewish pluralism or Jewish diversity. But having made that kind of a detour into Jew-on-Jew violence, right, I don't want to take our eyes off the ball here, right? Because the prime movers, the prime problematic actors, and the prime wrongdoers are not Jews, they are non-Jews, right? Who have a strong political incentive to delegitimize liberal Jews as not real Jews at all. And so while, again, the problem that we're facing is a free exercise jurisprudence that if it's taken literally just leads to anarchy, and a risk that has so far been ameliorated and masked by just who the religious claimants are and who's envisioned to be religious. And that masking is coming under increasing strain as liberal Jews challenge this presumption and bring the contradictions to the new free exercise to the fore. One way of resolving that would be to significantly narrow the new free exercise jurisprudence. But for judges who don't want to do that, they're going to need to look for a reason why liberal Jews can be locked out. And what we're already seeing is this ascendant form of anti-Semitic discourse that just doesn't recognize liberal Jews as Jews is a very attractive way of still preserving extremely expansive religious liberty protections for the true believers while locking out those who don't fit within a conservative Christian framework. So thanks so much for indulging me, and I'm happy to have a conversation.